Hi, I'm firearms attorney Gilbert Ambler, and today we're going to be talking about the mall shooter in Virginia, the Alan Coley case, the YouTube shooter, gone by a bunch of different terms. Many of you have been watching YouTube videos made by other attorneys, often attorneys outside of Virginia, or reading other content about this shooting, and there is some misinformation out there that I want to clear up. We're going to talk about it today, but as always, before we dive into it, if you have not yet hit that subscribe button, go ahead, hit subscribe. Like, comment with your thoughts, and share with your friends. That way you and your friends can keep getting this important Second Amendment related content. Now, just to set the stage here, Alan Coley was a Grubhub or some type of food delivery driver over in Northern Virginia in Loudoun County. And he goes to the mall to pick up food. When he's at the mall, he is approached by a YouTube prankster. In my opinion, none of his pranks seem very funny at all, but this YouTube prankster, Tanner Cook, approaches him, shoves a phone in his face, starts making some comments, and Mr. Coley tries to shove him away, tries to brush the phone away, asks him to stop a couple of times, and in response to this, the YouTube prankster gets even more aggressive, shoving the phone in his face. And after 3 or 4 shoves into the face with the phone, Mr. Coley turns, draws a firearm from his waistband, shoots a single shot, striking the YouTuber, Mr. Cook. Now, did not kill the YouTuber, but injured him. For his troubles, Mr. Coley was charged with malicious wounding, which is Virginia's version of an aggravated assault. He was charged with use of a firearm in commission of a felony. And finally, he was charged with discharge of a firearm into an occupied structure. Now, some of the misinformation that I've seen floating out there is as a result of the jury verdict. Because when this case went to trial, the jury came back and they exonerated Mr. Coley on the malicious wounding. They exonerated him on the use of a firearm in commission of a felony, but convicted him of felony discharge into an occupied structure. Now, Mr. Coley has since been released, but I've seen people out there on the internet saying that this is an example of bad Virginia law, and that Virginia law, that he was convicted because Virginia law does not contain in the statute an explicit self-defense defense to discharge into an occupied structure, and I don't think that is correct. Because what these people are opining on is the fact that if you go to the code and you look up discharge into an occupied structure in Virginia, the law itself does not say anything about self-defense or about justification or excusable use of force as a legal defense to that charge. But it doesn't mean that it does not exist as a defense. Because practicing in Virginia, one of the things you learn is that justification or excusable force as a defense to a legal charge is typically a common law defense, meaning it is not normally in statute. In fact, to the best of my recollection, the only place you find the term self-defense in statute in Virginia is a defense to the brandishing statute. And of course, we can use self-defense, again, the justifiable or the excusable, depending on the facts, use of force as a defense to far more than just brandishing. What does it mean when I say common law? I mean, it is a judge-recognized and a judge-created. We look at case law over the past several hundred years here in Virginia to see the fact that this is a recognized legal defense, even if it is not written into the statute that creates the crime. So, yes, I think that it is very possible to use justification as a legal defense to the crime of discharge into an occupied structure. And really, this is a segue. I've actually successfully used justification to stop somebody who has been accused of discharge into an occupied structure from being charged, which is a perfect segue into one of the other things I want to talk about. Because reportedly, there are multiple YouTube channels out there that are saying Mr. Coley was a member of the United States Concealed Carry Association, the USCCA, and he was dropped by the USCCA. Now, I don't know if that's true or not. I have not done my own research on it, but here's my opinion, if it is true. My opinion is that they probably should have covered him because he had enough to articulate why he was acting in self-defense, okay? He was able to get a self-defense jury instruction. He could explain. He wasn't like he was out looking for trouble. He was approached. He responded to the trouble that approached him. I will also tell you, my opinion might be unpopular. I don't think that this was lawful self-defense. I don't think that Mr. Coley met the requirements to use deadly force in this scenario. And it is a subjective intent requirement in Virginia. Was he subjectively in reasonable fear of death or great bodily harm that would justify his use of deadly force? think the facts, they're pretty iffy on this, and the biggest thing that I'm concerned with is in Virginia there's an overt act requirement. The attacker has to take a substantial step towards actually carrying out an attack that would result in death or great bodily harm. The YouTuber, again, being a little aggressive, I don't know that he ever took a substantial step towards actually carrying out this attack, although I think it's a good question for a jury. I'm just telling you, if I was sitting on the jury, I don't think there was enough there. I do think there was enough that if he had a self-defense insurance coverage, he probably should have been covered, assuming his membership was active and all of the other things that would be required to be eligible for coverage. Now, I will tell you that I represent and have represented members of a different program. I've represented members of a program called US Law Shield. And I have, in fact, successfully used the concept of justification where a US Law Shield member was being accused of discharge into an occupied structure after hitting a house while he was shooting back while he was being shot at. And in that case, the police wanted to charge him. I was able to sit down with the prosecutors and my client, and we were able to actually get him immunity to prevent him from being charged in that case. And Law Shield covered it. It was a Law Shield covered case. So the question of whether these programs out there actually cover such things, in my experience, yes, they do. I would also point out that there's some misinformation floating around that maybe some programs would exclude coverage due to the mall being, quote, a prohibited place. The mall is not a prohibited place in Virginia. If you're a Virginia licensed attorney, you know this. It is not. We have firearms preemption in Virginia. Gun laws have to come from the state level. Malls are not mentioned in the firearm restrictions in Virginia. Okay, that is a policy. That is not a law. There's a legal distinction there. So I think he was lawfully carrying there, even if the mall had a policy against it. So I don't think that would have been a reason. Also, the whole concept that these programs out there don't cover you if you are, quote, convicted or accused of a crime because they don't cover criminal acts. We're sort of leaving off the second part of the contractual language that most of these programs use, which is they don't cover criminal acts for which justification is not available as a defense. And of course, that is the difference between saying, hey, we don't cover DUIs because you can't use justification as a defense to the DUI, and a self-defense case like discharge into an occupied structure where you say, yes, we do cover that because justification is available as a legal defense. Okay, so we really need to include the entire contractual language if we're going to be breaking down these contracts. To just simply say they don't cover criminal acts, we're cutting the sentences short. Go back, read these contracts yourself. Final point that I want to make on this type of incident is the fact that the jury had inconsistent verdicts. Okay, so the jury convicted him of the discharge into an occupied structure, did not convict him of the malicious wounding or the use of a firearm in commission of a felony. Again, this is why some people on the internet have thought that perhaps it's because there is no statutory defense to the discharge into the occupied structure. I don't think that's what happened. I think the jury was aware that they could have used self-defense to excuse him on the discharge into the occupied structure as well. I think it's far more likely that the jury simply thought he deserved to be held responsible for something, but they just really hated the YouTuber. So they exonerated him on arguably the more serious charges, and then they convicted him of the less serious charge, which was still, unfortunately, a felony here because they wanted to hold him responsible for something. That would be an inconsistent jury verdict, but such a verdict is allowed in Virginia, and Virginia courts have said that, yes, juries are allowed to, quote, split the baby. Sometimes they think somebody should be excused on some things, but convicted on others. Even if they're inconsistent, juries are capable of doing that in Virginia. If you enjoyed this content, hit that subscribe button. Until next time.